Before we begin, a quick and important disclaimer. This video content is provided for educational and entertainment purposes only and does not constitute legal, financial, or insurance advice. The information discussed, particularly regarding the economic landscape of divorce and the concept of financial protection products in the U.S. Southwest, is based on current historical trends and available statistical data. Regulations regarding insurance and family law vary significantly by jurisdiction. Viewers are strictly encouraged to conduct their own due diligence, consult with qualified local legal professionals, and review state-specific statutes before making any decisions regarding their personal financial planning or risk management strategies. Consider the reality of your household finances. You have likely spent years calculating your retirement contributions, managing your mortgage interest rates, and diversifying your investment portfolio against market volatility. Yet, many Americans overlook one of the most statistically significant risks to their lifetime net worth: the economic dissolution of a marriage. In the U.S. Southwest, where state laws regarding community property create a unique financial ecosystem, the probability of marital dissolution carries a price tag that often rivals a total loss of an investment portfolio. What if the most substantial financial risk you face is not a market downturn, but a domestic transition that could trigger a total restructuring of your assets, your tax liability, and your long-term liquidity? Today, we are opening a 10-part masterclass into the reality of divorce insurance and the economic statistics that underscore why this conversation is moving from the periphery into the center of high-stakes financial planning. This video solves a fundamental problem: the lack of data-driven literacy regarding high-cost domestic financial events. If you are living in Arizona, New Mexico, Nevada, or Texas, your financial reality is governed by community property statutes that treat assets differently than in other parts of the country. Many individuals find themselves blindsided by the economic mechanics of separation, leading to unintended depletion of savings, unforeseen tax consequences, and long-term erosion of wealth. By the end of this series, you will understand the interplay between regional divorce rates, asset division dynamics, and the evolution of financial products designed to mitigate these specific economic risks. To understand why this is a critical topic in the Southwest, we must first look at the statistical foundation. The Southwest presents a unique economic environment. Arizona and Texas, for instance, are widely recognized for being community property states. In these jurisdictions, the law generally presumes that all property acquired by either spouse during the marriage is owned equally by both, regardless of whose name is on the title or the bank account. This legal framework has profound implications when a marriage ends. When a household experiences a divorce, the process is not merely a separation of two individuals. It is a forced liquidation and redistribution of a single economic unit. Consider a case study of a mid to high net worth household in Phoenix, Arizona. A couple with a joint portfolio consisting of real estate, business interests, and liquid assets faces a dissolution process. Under community property laws, the court does not simply look at whose paycheck funded the retirement account. It views the accumulated wealth as a shared product of the union. When that unit splits, the economic friction of separation, legal fees, appraisal costs, asset liquidation taxes, and the necessity of establishing two separate households with the same level of capital can result in an immediate net worth reduction for both parties. This is the economic friction point that insurance products are designed to address: the sudden, non-discretionary expenditure required to navigate the dissolution process. We see a clear trend in the Southwest regarding demographic shifts and financial volatility. High-growth states like Nevada and Texas have seen rapid influxes of professional populations. These individuals often arrive with significant assets, vested stock options, retirement accounts, and real estate. However, the legal architecture of the states they migrate to is distinct. A person moving from a state with equitable distribution laws to a community property state may not realize that their entire asset protection strategy has been fundamentally altered by their change in residence. This is not a matter of fault, it is a matter of mathematical risk. The data indicates that when these individuals undergo a major life transition like divorce, the economic impact is magnified by a lack of preparation for the specific state-level laws they now operate under. The concept of divorce insurance, or more broadly matrimonial risk management, is essentially an attempt to turn a highly volatile, unpredictable expense into a predictable, manageable line item. In traditional finance, we use insurance to shield ourselves from low-frequency, high-severity events. House fires are rare, but we insure for them because the cost of recovery is prohibitive. Divorce is statistically more common than a total loss house fire, yet it remains one of the few high-impact financial events that is rarely treated with professional risk management protocols. We will examine the Bureau of Economic Analysis data and local divorce filing trends to demonstrate how these patterns correlate with household debt loads. In states like New Mexico, where the economic landscape is often defined by a mix of public and private sector employment, the sudden loss of dual income efficiency can be catastrophic for credit ratings and debt-to-income ratios. When you analyze the divorce statistics of the Southwest, you are not just looking at social trends, you are looking at macroeconomic indicators of household instability. We are only at the beginning of this analysis. Over the next 9 segments, we will dissect the legal frameworks of community property, the mathematics of asset valuation during separation, and the way insurance underwriters are attempting to model these risks. We will look at real-world scenarios where lack of foresight led to total liquidation of assets and compare them against potential strategies for preserving liquidity. This is not about speculation or simplistic solutions. This is a deep dive into the intersection of family law, economic theory, and the evolution of financial protection. By removing the emotion and looking purely at the statistical risk exposure, we can construct a much more robust framework for long-term wealth preservation. You are not just preparing for a marriage, you are preparing for the potential economic reality of its end. Stay with us as we proceed to analyze the specific statutory pressures that make the Southwest the most interesting testing ground for these financial developments. The statutory pressures within the U.S. Southwest do not operate in a vacuum. They function as a complex mechanism that dictates how wealth is dismantled during a separation. When we analyze states like Texas, Arizona, and Nevada, we are looking at legal environments where the presumption of community property acts as a default financial rule. Imagine a professional couple, let us call them David and Elena, living in a major metropolitan hub like Austin, Texas, in 2026. David has spent the last decade building a successful consultancy firm, while Elena has managed the household and contributed to their long-term savings through consistent strategic investments. Under the community property statutes of Texas, the court operates under the assumption that the value generated by David's firm during the years of their marriage is not his alone. It is viewed as an asset of the marriage. If their marriage were to dissolve, the economic reality is not merely a split of bank accounts. It is a valuation of the firm, a determination of its community interest, and potentially, a forced restructuring of assets that were never intended to be liquidated. This is the point where the average household financial plan often shatters. The legal requirement for a fair and equitable division does not account for the tax implications of liquidating these assets. In a scenario where David must buy out Elena's interest in the business to keep it operating, the liquidity required for such a transaction could be staggering. This is where the concept of matrimonial risk management begins to make statistical sense. The risk is not just the end of the partnership. It is the forced sale of capital at potentially inopportune times due to the legal mandate to divide the estate. Consider the data on the decline of standard of living post-dissolution. In 2026, the financial impact for those over the age of 50 is particularly acute. We see that women in this demographic frequently experience a 45% decline in their standard of living following a divorce, while men often face a 21% decline. These are not merely social statistics. These numbers reflect the erosion of long-term retirement planning, the loss of pension value, and the immense cost of maintaining 2 households on the same pool of assets that was previously optimized for one. When you add the complexities of community property to these figures, you start to see why traditional financial products are being reevaluated. Think about the way debt is handled. In a community property state, the debts accrued during the union, the mortgage, the credit card balances, the business loans, are typically considered joint obligations. Imagine a scenario where one spouse has engaged in high-risk financial behavior unknown to the other. Upon the filing for dissolution, both parties are often held equally responsible for the total debt load. This is a profound exposure that most individuals never stress test. The historical trend in the Southwest shows that debt-related disputes are becoming a larger percentage of total litigation costs. The legal system is essentially asking for a comprehensive audit of every financial decision made over the course of the marriage. This level of scrutiny is why the shift toward private settlements is accelerating in 2026. Courts are increasingly expensive, and the public nature of the process often leads to a more aggressive and damaging division of assets. Smart financial planning now involves anticipating the legal mechanics before they are ever triggered. We are seeing a rise in the use of sophisticated tools to trace assets, from blockchain-based ledgers for digital assets to AI-driven document analysis that identifies potential financial disparities early in the process. The goal is to move the conversation from the courtroom to a controlled negotiation where the protection of the estate is the primary objective. +1. But how do we quantify the potential impact on your specific financial trajectory? We must look at the way wealth is structured. Most high-net-worth individuals in the Southwest hold their assets in a mix of retirement vehicles, real estate, and equity in private businesses. Each of these carries different tax consequences upon division. If a divorce forces the liquidation of a retirement account before retirement age, the individual may face significant tax penalties. If it forces the sale of real estate, there are capital gains to consider. These are not just legal hurdles. They are quantifiable financial risks that lower the total net value of the estate available to both parties after the dust settles. When you look at the statistics of marriage duration and failure rates, the math becomes clear. The average length of a marriage before divorce is roughly 8 years, and the failure rate for second marriages climbs even higher. This is not a distant, theoretical possibility for most households. It is a measurable risk factor that should be integrated into every financial strategy. We have been conditioned to prepare for market crashes and medical emergencies, yet we remain remarkably underprepared for the most common high-stakes event in the domestic cycle. We are setting the stage for a deeper exploration into the actual mechanisms of financial mitigation. We need to understand how the insurance industry is attempting to model these risks and whether or not the current frameworks offer any genuine security against the statutory realities of the Southwest. If you are currently operating in a community property jurisdiction, how do you even begin to categorize your assets to minimize potential exposure? And more importantly, what are the emerging trends in private mediation that are allowing individuals to bypass the most damaging aspects of the traditional divorce process? We are moving into the core of the masterclass, where we stop looking at the problem and start looking at the tools that are currently available to navigate this terrain. In the next segment, we will analyze the specific legal structures that prenuptial and postnuptial agreements provide in the Southwest, and why their role in risk management is being fundamentally redefined. You will learn the exact steps to evaluate your own asset protection strategy, and why the old models of financial planning are no longer sufficient in the face of modern divorce statistics. We are just getting started on the mechanics of protecting your long-term liquidity. When we talk about the legal architecture of the Southwest, we are really talking about the foundation of every financial contract within a marriage. Prenuptial and postnuptial agreements are the primary tools used in this region to circumvent the default rules of community property. By 2026, the perception of these documents has shifted from being tools of suspicion to becoming standard components of robust household risk management. Imagine a scenario with a couple, Sarah and Mark, both professionals in their early 30s living in Las Vegas, Nevada. They have combined assets including a starter home, a modest investment portfolio, and clear career trajectories. They recognize that if their union were to dissolve, the state law would require a rigid division that might not account for their individual contributions or their specific future financial needs. By drafting a well-structured agreement, they are essentially opting out of the generic state-mandated distribution model in favor of a private contract that they have custom-tailored to their own economic realities. The reason this is critical in the Southwest is the statutory presumption that all assets are joint. Without an agreement, the court in a state like Arizona or Texas will prioritize the equal division of everything acquired during the union, regardless of the individual effort or financial source. This can lead to inefficient outcomes. For example, if one spouse has invested heavily in a specialized education or a specific career track that has not yet yielded significant cash flow but carries high future earning potential, the other spouse could argue for a share of that potential future value under community property statutes. This is the source of extreme financial friction. A contract provides the framework to define separate property and clarify expectations, which significantly reduces the potential for long, high-cost litigation. Consider the economic data regarding litigation costs. In high-conflict divorce cases in the Southwest, legal fees can often exceed 20 to 30% of the total marital estate. This is a massive, non-recoverable loss of wealth. When you look at the statistics, it becomes evident that the highest costs are consistently associated with disputes over asset valuation and the classification of property. When a couple has a clear, legally sound agreement in place, they have essentially predetermined how these issues will be resolved. They have created a private, negotiated exit strategy that avoids the public court process. This is the definition of risk mitigation. They are protecting the estate from the unpredictable and costly mechanics of the public legal system. The role of postnuptial agreements is also becoming increasingly important in 2026. Many couples do not address these issues until after the marriage has begun, perhaps when one party inherits a significant asset or one starts a business that becomes a major component of their net worth. A postnuptial agreement allows a couple to adjust their financial reality to reflect new developments. If Sarah and Mark from our previous example start a company together 3 years into their marriage, they can draft a postnuptial agreement that outlines exactly how that business interest will be handled if the marriage were to dissolve. This provides clarity and prevents the business from becoming the focal point of a contentious legal battle. It is important to understand that these agreements must be structured with professional guidance to be effective. The historical trends show that the most common reason these contracts are challenged in court is a lack of full financial disclosure or perceived coercion during the drafting process. If one party hides assets or if the terms are found to be unconscionable, a judge in a community property state may decide to invalidate the agreement and revert to the default laws. This is why transparency is the key to creating a lasting and enforceable contract. The goal is to provide a level of certainty that satisfies the court, while allowing the couple to maintain control over their assets. We are also seeing a shift toward using arbitration and private mediation as an alternative to the traditional court system. In the Southwest, there is a growing network of specialized legal professionals who act as mediators for high-net-worth couples. These individuals are trained in the specific economic nuances of the region, including the tax implications of asset division in community property states. By using these services, couples can often reach a settlement that is far more efficient than anything a judge would order. The financial statistics consistently show that mediated outcomes result in higher net value retained by both parties. Think about the implications for your own financial trajectory. If you are part of a dual-income household in the Southwest, you are essentially operating a small business together. You have shared assets, shared debts, and shared long-term goals. Every business contract includes a dissolution clause. Why should your household be any different? By addressing these issues proactively, you are not predicting the end of your marriage. You are acknowledging the reality of risk and putting protections in place to ensure that both parties remain on a stable financial footing, no matter the outcome. The data suggests that the next phase of this evolution will be the integration of insurance products specifically designed to cover the costs associated with these legal separations. These products are being modeled to pay for the professional fees, the appraisal costs, and the sudden liquidity requirements that arise during a divorce. As the actuarial data becomes more robust, we can expect to see more of these offerings entering the market. In the next segment, we will dive into the mathematics of how these insurance products are being priced and the specific criteria that underwriters are using to assess risk in the Southwest. We will examine why the stability of a couple's financial documentation is becoming a primary indicator for their insurance premiums. You will see why the work you do now, in documenting your assets and establishing clear agreements, is directly linked to the future availability and affordability of these protective products. We are transitioning from the legal framework into the actuarial heart of the matter. The actuarial heart of the matter lies in how risk is quantified, categorized, and ultimately priced. In the world of high-stakes insurance, underwriters do not deal in speculation. They deal in probabilities derived from vast datasets, and when it comes to matrimonial risk, the data is increasingly granular. Imagine an underwriter at a firm evaluating a policy application in 2026 for a couple in Dallas, Texas. They are not looking at the health of the relationship, they are looking at the health of the financial structure. They analyze the volatility of the assets, the clarity of existing legal agreements, and the debt-to-income ratios that define the household's economic stability. Underwriting is the process of assessing whether a specific risk is insurable and at what cost. For matrimonial risk products, the primary factors are the stability of the income streams and the complexity of asset distribution. If a couple has clearly separated their assets via prenuptial or postnuptial agreements, the underwriter sees a lower risk of unpredictable, high-cost litigation. They see a documented, prearranged exit strategy. Conversely, if the couple has commingled all their assets over a 15-year period, the underwriter sees a high-frequency, high-severity event waiting to happen. The pricing of the premium will reflect this distinction because the cost to the insurer for handling a messy, high-conflict divorce, where assets must be forensically traced and valued, is exponentially higher than for a clean, contractually defined dissolution. Think about the way this model compares to more traditional lines of insurance. In life insurance, for example, the primary factor is mortality risk, calculated using medical history, age, and lifestyle habits. In matrimonial risk management, we are calculating economic friction risk. Underwriters look at historical trends in state-level divorce filings, the average cost of legal representation in specific jurisdictions, and the typical length of time it takes to settle a case in a community property state. They are essentially modeling the time value of money against the probable duration of a legal dispute. If the data shows that divorces in a specific county tend to drag on for 2 years, the insurance product must be structured to cover the ongoing expenses and the potential erosion of assets over that 2-year period. There are also behavioral factors being integrated into these models. We see that individuals who have undergone previous high-conflict transitions, whether in business or personal life, may be categorized differently. The industry is utilizing sophisticated document analysis to evaluate the quality of a couple's existing financial records. A couple that maintains regular, professional audits of their assets is a lower risk than one that treats financial management as an afterthought. This is why the work you do now, the meticulous tracking of property, the clear documentation of separate versus community funds, is a direct component of your risk profile. The more transparent your financial reality, the more predictable the outcome, and consequently, the more manageable the insurance premium. However, there is a fundamental tension in this market. Insurance is meant for rare, catastrophic events. Divorce, as we have noted, is increasingly common, which makes it difficult to price as a standard indemnity product. This is why we see these products evolving more toward legal expense coverage and financial mediation support. The goal is not to pay out a lump sum that replaces the lost wealth, but to provide the capital required to navigate the process without destroying the remaining estate. It is about maintaining liquidity in the face of a massive, non-discretionary shock to your net worth. Consider the case of a business owner in New Mexico. If their business is their primary asset, the threat of divorce is a threat to the existence of the company. A well-modeled insurance product for this individual would focus on providing immediate access to capital for buyouts or for funding the legal costs required to defend the business's valuation. It does not prevent the divorce, but it prevents the divorce from being a business-ending event. This is the shift in perspective that is defining the 2026 financial landscape. We are moving from viewing divorce as an emotional failure to viewing it as a catastrophic financial event that requires professional, structural mitigation. The data further shows that the most impactful risks in 2026 are economic in nature, and the uncertainty surrounding these events is what drives the cost of premiums. We are witnessing a professionalization of the entire divorce process. Forensic accountants, specialized mediators, and legal experts are becoming as common in the divorce process as they are in a corporate merger. The insurance industry is simply providing the financial architecture to support this more professionalized approach. But what happens when the legal framework itself is in flux? We have discussed how community property creates a unique set of pressures, but the interpretation of these laws is constantly evolving. In the next segment, we will analyze the emerging case studies where innovative settlements successfully navigated these pressures without resorting to public litigation. We will look at the specific steps these couples took to secure their liquidity and how they utilized private, confidential frameworks to protect their estates. This is not just theoretical. We will look at how the 2026 economic environment is forcing a change in how even the courts view these private agreements. We are about to look at the exact mechanics of how these settlements are constructed and why the most successful ones never see the inside of a courtroom. You will start to see the blueprint for a modern, protected financial life, regardless of what the future holds for your household. The transition from risk assessment to active settlement strategy is where the real value is created. Stay with us as we uncover the tactics of the elite in managing these high-stakes transitions. The elite in the high-stakes world of finance do not leave their wealth to the arbitrary decisions of a courtroom. They treat the separation of a financial estate with the same analytical rigor as a major corporate merger. In 2026, the strategy for preserving capital during a high-net-worth divorce in the U.S. Southwest is defined by proactive, confidential, and interest-based negotiations that prioritize long-term liquidity over short-term adversarial victory. Consider the tactical approach of a high-net-worth individual. Let us call her Sarah, who owns a substantial portfolio of private businesses and real estate in Arizona. If her marriage were to dissolve, The default community property statutes would demand an equal division of assets. Without a strategy, this would necessitate the forced liquidation of her businesses and properties to pay out her spouse, resulting in massive tax consequences and the complete destruction of her business continuity. Instead, Sarah utilizes a team of forensic accountants, tax strategists, and specialized legal counsel to construct a settlement that circumvents this default path. They do not fight, they negotiate. They model multiple settlement scenarios, asset swaps, structured buyouts, and tailored support levels, with the explicit goal of maintaining the structural integrity of her business operations. +1. The core of this elite strategy is the creation of a comprehensive asset inventory. This is not a simple list of bank accounts. It is a detailed, itemized record of every marital and separate asset, supported by professional appraisals, corporate agreements, and digital asset logs. In the Southwest, where the presumption of community property is the baseline, this documentation is the first and most critical line of defense for protecting separate property, inheritances, premarital assets, and gifts from being commingled and lost in the division process. The clarity of this baseline creates a defensible position that significantly restricts the ability of the opposing party to contest asset valuations. +1. Beyond valuation, the strategy shifts to tax-efficient restructuring. A 50-50 division on paper rarely translates to equal results after taxes. For instance, receiving 50% of a retirement account involves a different tax reality than receiving 50% of a brokerage account with a low-cost basis. By using in-kind transfers instead of liquidating assets, these settlements defer tax liability and allow each spouse to retain control over their investment strategy. They also utilize qualified domestic relations orders to facilitate clean transfers of tax-deferred accounts, ensuring that the division does not trigger immediate penalties. This is not about winning the most assets. It is about retaining the most net after-tax value. +4. Private mediation is the preferred venue for these negotiations. Unlike a public courtroom, where financial disclosures and business interests become part of the public record, exposing sensitive details to media and potential competitors, mediation takes place behind closed doors. This confidentiality is paramount for high-net-worth individuals who value their privacy and business reputation. A neutral third-party mediator, often an experienced divorce attorney with deep knowledge of local economic nuances, facilitates the dialogue, guiding the parties to craft a settlement that serves their specific financial situation rather than a generic court order. They can negotiate creative solutions like staggered asset distributions, long-term buyouts, and customized support structures that preserve cash flow. +3. This process is fundamentally analytical. It is about identifying areas of agreement and keeping the negotiation focused on the objective, maintaining the estate. If the parties can maintain this perspective, they avoid the astronomical costs of prolonged litigation, which can easily devour 20 to 30% of the total marital estate in legal fees and expert costs. The goal is a settlement agreement that, once finalized and reviewed by counsel, is submitted to the court as a binding contract. This approach turns a potential financial catastrophe into a managed transition. +1. However, even with the most meticulous settlement, the post-divorce reality requires a fundamental reset of financial planning. This includes updating wills, trusts, and beneficiary designations, and restructuring investment portfolios to align with individual rather than shared objectives. The elite understand that a settlement is not an endpoint. It is a financial reset that requires ongoing oversight. +1. We are now uncovering the layers of how these protective strategies directly integrate with the developing insurance models we mentioned earlier. If the elite are increasingly utilizing these private, structured settlements to manage their risk, how does the insurance industry respond? In the next segment, we will analyze the specific underwriting criteria for matrimonial risk policies in the Southwest, and why the quality of your settlement structure directly dictates your insurability. We will examine the data on how insurers are shifting their focus from simple indemnity toward providing the actual capital necessary for high-stakes mediation. The transition from active strategy to long-term risk transfer is where this masterclass hits the most critical, actionable phase. Stay with us as we evaluate why the market for these products is expanding in 2026. The expansion of the matrimonial risk insurance market in 2026 is driven by a simple economic reality. The cost of traditional divorce litigation has become an unsustainable drain on capital in the U.S. Southwest. When insurers evaluate these risks, they are moving away from the simplistic view that divorce is an uninsurable personal event. Instead, they are analyzing it through the lens of contract law and actuarial science. They are looking for the same stability in a household that they would demand from a business entity seeking liability coverage. Consider the case of a professional in 2026. Let us call him Robert, living in Albuquerque, New Mexico. Robert is looking for financial stability in his long-term planning. When he explores the emerging market of matrimonial risk protection, he finds that underwriters are scrutinizing the quality of his existing financial documentation. They are not interested in the state of his marriage, but they are deeply interested in the state of his balance sheet. The underwriter asks, does Robert have a clear, enforceable prenuptial agreement that separates his professional assets from his personal household holdings? Has he maintained regular independent audits of his business valuation? Is his debt structured in a way that minimizes exposure to joint liability? These are the factors that determine his insurability. The underwriting process for these products is rigorous. It involves a deep dive into the historical trends of divorce filings in the specific county where the applicant resides. Insurers use this data to model the probability of a dissolution event within a specific time frame. They then overlay this with the complexity of the household's asset portfolio. If the couple has high-value illiquid assets, such as a stake in a private business, commercial real estate, or venture capital holdings, the premium will be higher because the potential cost of managing the division of these assets is greater. The insurer is effectively pricing the cost of the legal and forensic resources they would need to deploy to ensure the process remains within the boundaries of the policy. What is changing in 2026 is that these policies are increasingly structured to act as a source of immediate liquidity. Imagine if Robert encounters a dissolution event. The policy does not pay out for emotional distress. It pays out to cover the costs of the professional team required to protect his financial interests. It provides the capital to hire top-tier forensic accountants who can ensure the business valuation is accurate and the asset division is optimized for tax efficiency. It covers the costs of private mediation, allowing Robert and his spouse to resolve their disputes out of court, maintaining privacy and business continuity. This is a direct transfer of risk. The insurer assumes the cost burden of the legal and advisory process, protecting the individual's core liquidity from being eroded by the friction of a public, drawn-out legal battle. This represents a paradigm shift. We are moving from a reactive state, where an individual is forced to scramble for capital during a transition, to a proactive state where the capital is ready and available because it has been pre-insured. This allows the individual to maintain their financial strategy, even during a period of intense personal change. The data indicates that the individuals who utilize these products are, on average, retaining a significantly higher percentage of their net worth during marital dissolution compared to those who rely on the default, non-insured process. The growth of this market is also supported by the increasing professionalization of divorce-related services. In 2026, there is a robust ecosystem of experts, specialized divorce planners, high-net-worth mediators, and forensic valuation analysts, who are all working to make the process more predictable and less damaging. Insurance products are becoming the financial backbone of this ecosystem. By providing the funds to engage these experts, the insurance companies are creating a self-reinforcing cycle. The experts use their skills to protect the assets, which in turn reduces the severity of the loss for the insurer, allowing them to offer more competitive premiums. However, it is crucial to recognize that this is a highly technical and evolving sector of the insurance industry. There is no off-the-shelf product that fits everyone. The structure of these policies is deeply tied to the specific state laws, as the legal requirements for asset division in Nevada are distinct from those in Texas. Any individual looking into these products must work with brokers who specialize in high-net-worth risk management and who understand the intersection of family law and insurance underwriting. As we deepen our analysis, we must look beyond just the availability of these products. We need to understand the limitations and the specific conditions that can void a policy. What happens if there is a documented history of financial misconduct? What happens if the legal agreement between the spouses is found to be deficient? These are the details that matter. In the next part of this masterclass, we will examine the critical role of forensic accounting in validating the asset base for insurance underwriting, and why this practice is becoming the gold standard for protecting net worth in the Southwest. We will see why the most successful financial plans in 2026 are those that incorporate a continuous, objective audit of the estate, and how this audit process provides the most significant protection against the catastrophic loss of wealth. The transition from planning to verification is where the most resilient financial structures are built. You will learn the exact steps to audit your own assets, and why this process is the final hurdle before your estate can be fully protected by these modern financial tools. Stay with us as we uncover the precision required for the highest level of asset defense. The precision required for the highest level of asset defense in 2026 relies on a discipline that is moving from the periphery into the center of high net worth financial planning: forensic accounting. When we speak about protecting an estate from the unpredictable dynamics of a community property state in the Southwest, we are speaking about the necessity of absolute financial transparency. Imagine a professional household in 2026. Let us call them David and Elena, living in Dallas, Texas. They possess a diverse portfolio including a private tech consultancy, multiple real estate holdings, and various investment accounts. Without a forensic audit, their financial picture is merely a collection of tax returns and account statements, documents that rarely reflect the actual economic reality of a marital estate. Forensic accounting is not about traditional bookkeeping. It is financial detective work. It involves a systematic, skeptical examination of all financial records to identify irregularities, misrepresentations, or hidden assets. In a high-stakes divorce, where the presumption of community property creates an environment of intense scrutiny, forensic accountants provide the objective truth that both parties, and the court, need to reach an equitable settlement. They look for the red flags that an average audit might miss: sudden increases in business expenses that look suspiciously like personal lifestyle funding, large unexplained transfers to related parties, or revenue timing shifts designed to temporarily deflate the perceived value of a business. Plus 3. The process is methodical. The accountant begins by mapping the entire financial landscape of the marriage. They gather everything: tax returns, bank statements, general ledgers, credit card records, and corporate filings. They then perform a lifestyle analysis, comparing reported income with actual expenditures. If David claims to earn a modest income but the family maintains a luxury lifestyle that requires significantly more, a forensic accountant will identify this discrepancy and investigate the source of the hidden funds. This is a crucial defense mechanism. By establishing the true economic standard of living, they ensure that support calculations are based on reality rather than manipulated financial statements. Plus 4. Business valuation is perhaps the most critical function of the forensic accountant in these scenarios. A private business is rarely valued by a simple ticker symbol. It requires a deep dive into its books, its market position, and its future earning potential. A spouse who owns the business has a strong incentive to minimize its value during the dissolution. The forensic accountant identifies this potential for manipulation. They analyze related party transactions, look for asset transfers that occurred shortly before the divorce filing, and calculate the normalized earnings of the business, the amount it would realistically earn under normal operating conditions. This normalized value is the true figure that should be considered for distribution. Plus 3. The goal of this process is to provide the hard, admissible evidence that can either be used to secure a fair settlement in private mediation or to present a bulletproof case in court. When you have a comprehensive, verified asset inventory, you are not engaging in speculation. You are dealing in facts. This level of clarity is the ultimate protection against the erosion of your estate. It prevents one party from gaining an unfair advantage and ensures that every dollar is accounted for. It removes the ambiguity that often fuels conflict and drives up legal costs. Plus 1. However, the value of this process extends beyond the divorce itself. It is a tool for ongoing financial health. An estate that is audited regularly is an estate that is fundamentally stronger. It forces the identification of inefficiencies, the correction of accounting errors, and the consolidation of complex financial structures. By 2026, the elite are recognizing that this form of continuous financial verification is the best preparation for any major life transition. It provides a foundational understanding of one's own net worth that is difficult to shake, regardless of the legal or economic pressures encountered. We are seeing that the most successful financial strategies in the U.S. Southwest are those that embrace this level of rigor. They do not wait for a crisis to understand their own balance sheet. They maintain a living, breathing record of their assets, debts, and income streams that is always ready for review. This is not about suspicion. It is about operational excellence. When you know exactly what you have and what it is worth, you are in a position of strength, not desperation. But what happens when you find an anomaly during this process? How do you address it without triggering the very conflict you are trying to avoid? In the next segment, We will analyze the delicate art of financial negotiation in a high-stakes setting. We will look at how to use the information uncovered by a forensic audit to facilitate a structured settlement that protects your liquidity without resorting to the adversarial tactics that characterize the traditional, broken system. We will explore the specific strategies for translating complex financial findings into a clear, persuasive narrative for mediation. You will understand how to leverage your financial truth to create a path forward that preserves your wealth and your future. The transformation of raw financial data into a settlement strategy is the final, pivotal step in our masterclass. Stay with us as we move from the detective work of the audit into the boardroom strategy of the settlement. The transition from the investigative rigor of a forensic audit to the strategic environment of the boardroom is where the most successful financial outcomes are determined. In 2026, the elite in the U.S. Southwest view a marital dissolution not as a battle to be won in the public eye, but as a complex transaction to be resolved behind closed doors. The objective is to utilize the objective facts unearthed during the audit to construct a narrative that justifies a specific settlement, one that protects the structural integrity of the estate while satisfying the legal requirements of the community property system. Imagine the situation of a business owner, let us call him Michael, based in Phoenix, Arizona. Michael has spent 2 decades scaling his manufacturing company. Following a rigorous forensic audit, the true valuation of his firm is established, and the financial reality of the marital estate is laid bare. Now Michael and his legal counsel must enter the mediation boardroom. Their goal is not to force a concession, but to demonstrate that maintaining the continuity of the business provides the highest potential value for both parties. This is the art of negotiation, moving from a position of adversarial conflict to one of cooperative problem-solving, anchored by the cold, hard numbers of the audit. The first step in this boardroom strategy is the alignment of narratives. Every party involved in the dissolution has a view of what is fair. The forensic audit acts as the single objective source of truth. When the numbers are indisputable, the space for unproductive argument is significantly reduced. Michael's counsel presents the data not as a weapon, but as a roadmap. They explain the tax consequences of various division scenarios, showing how a forced sale of business assets would trigger capital gains taxes that benefit neither Michael nor his spouse. They provide a model of what a structured long-term buyout would look like, demonstrating how it ensures that the spouse receives the full, fair market value of their community interest, while allowing the company to thrive. This is a critical distinction in the Southwest. Because community property laws are rigid, you cannot simply hide assets or misrepresent value. You must work within the law to reach an outcome that is equitable. The data shows that the most successful mediators in Arizona and Texas are those who excel at this kind of sophisticated, interest-based negotiation. They understand that a settlement is a puzzle, not a zero-sum game. They look for ways to balance the liquidity needs of one party with the long-term growth objectives of the other. For instance, they might structure a settlement that combines a lump sum payment with a long-term note, or an exchange of interests in different assets that results in a tax-efficient outcome for both sides. The boardroom strategy also involves a deep understanding of the regulatory landscape. Your counsel must be able to articulate why a certain settlement structure is compliant with state statutes and why it serves the interest of both parties. They must be prepared to address the concerns of the mediator, who is focused on reaching an agreement that will hold up under court review. This requires a level of professional coordination that is only possible when you have the right team in place: legal, financial, and tax experts who are all working from the same factual foundation. Consider the potential for unexpected hurdles. Even with a perfect audit and a clear strategy, emotions can flare. The boardroom strategy includes specific protocols for managing these moments. It emphasizes a focus on the long-term financial reality rather than short-term grievances. It uses the objective data to bring the parties back to the table, consistently reminding them of the shared objective, to emerge from the process with their net worth as intact as possible. The historical trends confirm that the most effective negotiators in these high-stakes scenarios are those who stay focused on the mathematical bottom line, treating the process as a rational project rather than an emotional battle. Furthermore, we are seeing the rise of what can be called settlement modeling software. In 2026, sophisticated platforms allow counsel to input different settlement structures and immediately see the projected long-term impact on both parties' balance sheets. This allows for real-time negotiation where the impact of a proposed change can be evaluated in seconds. It allows for a level of transparency and efficiency that was impossible just a few years ago. This technology is becoming a standard tool in the mediator's toolkit, further accelerating the movement toward settlement and away from litigation. What is truly fascinating is how this boardroom-style approach to marital dissolution is beginning to influence other areas of financial planning. We are seeing a shift where couples are starting to apply these same rigorous documentation and negotiation principles to other aspects of their lives: long-term estate planning, business partnership agreements, and family investment offices. They are adopting the mindset that any shared financial venture, regardless of its nature, requires the same level of analytical rigor and proactive risk management. We are nearing the end of this deep dive, but we have one final crucial area to address. We have discussed the forensic audit, the boardroom strategy, and the role of insurance as a potential mechanism for liquidity. Now we must synthesize all of this into a comprehensive roadmap for long-term financial resilience in the U.S. Southwest. We need to look at the big picture. How do you integrate these elements into a personal financial plan that is robust enough to survive any potential dissolution event? In the next segment, we will lay out the exact step-by-step framework for building this resilience. We will look at how to maintain your documentation, how to regularly test your asset protection strategies, and why the most secure individuals in 2026 are those who view their estate with the constant, watchful eye of a professional manager. You will learn the final keys to insulating your wealth from the systemic risks of the Southwest. Stay with us as we finalize your masterclass in financial defense. Insulating your wealth from the systemic risks of the U.S. Southwest requires a shift in mindset. You must stop viewing your personal financial life as a static collection of accounts and start managing it as a dynamic, high-stakes corporate entity. In 2026, the most resilient individuals in states like Texas, Arizona, and Nevada are those who have internalized the principles of objective financial management. They do not wait for a crisis to stress test their estate. They treat every year as an opportunity to audit, verify, and secure their assets against the inevitable volatility of domestic life. The roadmap to this resilience begins with the maintenance of a continuous financial audit. As we have discussed, a forensic accounting audit is the gold standard for protecting net worth. But this is not a one-time event. For the highest level of security, you should implement a recurring semi-annual review of your asset inventory. This involves more than just balancing a checkbook. It requires you to track the acquisition and disposal of assets, document the source of all funds used for significant purchases, and maintain a clear, updated record of separate versus community property. Think of this as the corporate governance of your household. If you are ever forced to justify the classification of an asset in a courtroom, you want a decade of verified, organized documentation, not a collection of fragmented emails and memory-based claims. This documentation must be stored in a secure, redundant system that is accessible to your trusted advisors, such as your legal counsel and your financial planners. By 2026, many are utilizing secure, cloud-based digital vaults to maintain this repository, ensuring that all necessary information is instantly available if a transition occurs. This is not about paranoia, it is about operational readiness. If you have clear, undisputed records, you significantly reduce the potential for legal conflict, as there is little room for opposing parties to contest the nature of your property. The next step in the roadmap is the proactive management of debt. In community property jurisdictions, debt is as much a part of the marital estate as assets. A resilient financial plan includes a rigorous debt management strategy. You should be aware of the credit agreements you enter into, both individually and jointly. It is important to perform regular reviews of your credit reports and to understand the liability exposure you have for any debts incurred by a spouse. In scenarios where a spouse engages in high-risk financial behavior, the ability to demonstrate that you were unaware of or did not benefit from that debt can be a critical legal defense. You must also integrate these strategies with your overall estate and investment planning. This means ensuring that your wills, trusts, and beneficiary designations are not only current, but are also aligned with your broader asset protection goals. If you have established a separate property structure, ensure that your estate planning documents reinforce this distinction. A trust that is improperly funded can become a massive liability during a divorce, as it may be viewed as commingled property. Working with legal experts who specialize in the intersection of family law and estate planning is the only way to ensure that your structures are defensible. The final and perhaps most important key to resilience is the cultivation of a professional support network. You should have a standing team of experts who understand the nuances of the Southwest economic environment. This team should include a family law attorney, a forensic accountant, and a financial advisor who is experienced in high net worth risk management. These professionals should communicate with each other, ensuring that your legal agreements, your accounting records, and your investment strategy are all perfectly aligned. They are not just reacting to your problems, they are proactively managing your risk profile. This roadmap is not about predicting the future. It is about acknowledging that we live in a world where economic and domestic instability are measurable, quantifiable risks. The goal of financial defense is not to avoid the reality of these risks, but to insulate yourself from their most damaging effects. By being disciplined, organized, and proactive, you gain a level of control that most individuals never experience. You are no longer at the mercy of the default legal system. You are the architect of your own financial future. We are now at the final stage of our journey. We have dissected the mechanics of the legal system, analyzed the actuarial data, explored the boardroom tactics of the elite, and outlined the roadmap for long-term resilience. But there is one final overarching question to answer. How do you synthesize all of this into a daily habit of professional financial management? In the final segment of this masterclass, we will provide the ultimate implementation guide. We will look at the daily, weekly, and monthly rituals that keep your estate protected and your mind clear. We will discuss why the ultimate protection is not a single document or a single insurance policy, but a consistent, professional approach to every financial decision you make. You will leave this series with the exact blueprint for a protected, high-performance financial life. Stay with us as we conclude our masterclass and set you on the path to total financial autonomy. The final step in your journey to financial autonomy is the translation of theory into daily operation. Protecting your net worth in the U.S. Southwest is not a set of actions you perform once. It is a permanent adjustment to your professional habits. By 2026, the elite are defined by their consistency. They do not view their financial life as a set-it-and-forget-it system, but as a living enterprise that requires constant oversight, rigorous data management, and an unwavering commitment to transparency. To implement this, you must adopt a tiered system of financial rituals. Start with your daily and weekly habits. Your professional life likely already involves tracking performance metrics, managing cash flow, and reviewing key deliverables. Your household should be no different. Dedicate time each week to review your financial dashboard. This is not about obsessing over every purchase. It is about ensuring that your financial records are up to date and that there are no discrepancies in your accounts. Verify that all your assets are accounted for, check that your debt obligations are serviced, and ensure that your documentation, from receipts for significant purchases to updates on corporate filings, is being archived properly. Move to your monthly and quarterly rituals. This is where you conduct your higher-level reviews. Every month, meet with your spouse to review your shared financial goals and the status of your collective estate. This is not a time for conflict. It is a business meeting to ensure that both parties are aligned on the strategy. Discuss the performance of your investments, review your budget against actual expenditures, and confirm that your asset protection strategy is still relevant to your current financial standing. If your estate has grown or shifted, for example, if you have started a new business or acquired new real estate, this is the time to assess if your legal and insurance structures need adjustment. Your quarterly ritual should involve a check-in with your professional support team. A brief, high-level meeting with your financial advisor or legal counsel ensures that you are staying ahead of any regulatory or economic shifts in the Southwest. Ask the hard questions. Is our current trust structure still the most efficient? Are our insurance policies sufficient to cover our current net worth? Do our existing prenuptial or postnuptial agreements still reflect our financial reality? This proactive communication prevents small issues from compounding into massive liabilities. The ultimate goal of these rituals is the cultivation of a defensive mindset. When you manage your household with the precision of a professional business, you insulate yourself from the systemic risks that plague the average individual. You are no longer susceptible to being blindsided by financial volatility. You know your baseline, you know your exposure, and you have the data to support your position no matter the circumstances. This is the definition of financial autonomy. You are not waiting for someone else to protect you. You have built the infrastructure to protect yourself. Consider the case of a couple, let us call them Marcus and Sarah, living in Las Vegas in 2026. They have fully adopted this professional model. Their financial life is organized, transparent, and legally defended. They have a comprehensive asset inventory. Their business interests are properly structured to protect against community property exposure, and they have secured insurance coverage that provides a safety net for their liquidity. When they look at the divorce statistics in the Southwest, they do not feel vulnerable. They feel prepared. They have removed the unpredictability from their financial future. This is the outcome we have been working toward throughout this series. The ability to live with confidence, knowing that your long-term wealth is protected by the rigor of your own preparation. As we close this masterclass, remember that the tools we have discussed, forensic accounting, board-level negotiation, and proactive risk transfer, are not just for the elite. They are tools of intelligence and discipline. Anyone can adopt these habits. Anyone can begin the process of organizing their financial life, documenting their assets, and seeking professional guidance. The difficulty is not in the tools. It is in the commitment to start and the consistency to maintain. You now possess the blueprint. You understand the legal landscape of the U.S. Southwest, the actuarial reality of matrimonial risk, and the strategies that work to preserve capital. You know how to audit, how to negotiate, and how to structure your estate for maximum resilience. The path to financial autonomy is clear. It is a path of transparency, precision, and proactive management. It is a path that requires you to step up, take control of your financial life, and treat your estate with the respect it deserves. Your journey into professional financial defense begins today. Start with a single step. Organize your most critical financial documents, conduct your first high-level audit, and reach out to the professionals who can help you secure your future. The economic reality is what it is, but your position within it is something you can manage. You have the knowledge. You have the framework. The rest is simply a matter of execution. Build your defense, preserve your legacy, and move forward with the clarity that only comes from knowing your financial life is secure.